Welcome to the Supreme Court of the United Kingdom. We are handing down judgment today in the case of the Test Claimants in the Franked Investment Income Group litigation and the Commissioners for Her Majesty's Revenue and Customs. This is a brief summary of the Court's reasoning. The appeal arises in the course of long-running proceedings known as the Franked Investment Income Group litigation. That litigation brings together many claims concerning the way in which tax used to be charged on dividends received by companies resident in the UK from subsidiaries resident overseas. This appeal involves claimants within the FII group litigation whose cases have been selected to proceed as test claims on common issues. Those issues are being determined in phases, with the Court's decisions affecting not just the other claims within the FII group litigation, but also other sets of proceedings brought against the Commissioners for Her Majesty's Revenue and Customs, HMRC. The test claimant's case is that differences between their tax treatment and that of wholly UK resident groups of companies breached EU law. They seek repayment of the tax which they paid from 1973, when the UK entered the EU, on the basis that they paid it under the mistaken belief that it was lawfully due. They also seek interest dating back to 1973. Claims for the recovery of money must normally be brought within 6 years from the date on which the money was paid. As an exception to that general rule, Section 32(1)(c) of the Limitation Act 1980 provides that in respect of an action for relief from the consequences of a mistake, the 6-year period only begins to run when the claimant has discovered the mistake or could with reasonable diligence have discovered. Before the Court of Appeal, the test claimants argued that where a claimant is seeking to recover money paid under a mistake of law, the effect of Section 32(1)(c) is to postpone the commencement of a 6-year period until the true state of the law is established by a judicial decision from which there lies no right of appeal. The test claimant said that this was when, in 2006, the Court of Justice of the European Union decided the relevant aspects of the UK tax regime were incompatible with EU law. HMRC argued that time instead began to run in 2001, when the Court of Justice decided that other aspects of the UK tax regime breached EU law. The Court of Appeal found in favour of the test claimants on this issue. On appeal to the Supreme Court, HMRC argued that Section 32(1)(c) applies only to mistakes of fact and not to mistakes of law, or alternatively, that the test claimants could reasonably have discovered their mistake more than 6 years before they issued their claims in 2003. On either approach, a proportion of the claims would be time-barred. The Supreme Court unanimously allows HMRC's appeal, but for differing reasons. The majority hold that Section 32(1)(c) applies to claims for the restitution of money paid under a mistake of law, with time beginning to run when the claimant discovers or could with reasonable diligence have discovered their mistake, in the sense of recognising that they have a worthwhile claim. It leaves the application of that test to the facts of this case for the High Court, after the parties have had an opportunity to amend their pleadings. The minority of the Court would have held that Section 32(1)(c) has no application to mistakes of law. Lord Hodge and I give the main judgment with which Lord Lloyd-Jones and Lord Hamblin agree. Lord Briggs and Lord Sales give a partially dissenting judgment with which Lord Carnwath agrees. The Court rejects the test claimant's various objections to HMRC arguing at this stage of the proceedings that Section 32(1)(c) does not apply to mistakes of law. In particular, the Court considers that HMRC's challenge does not amount to an abuse of process when seen in the context of group litigation which raises novel issues of unparalleled complexity, and which was the subject of case management decisions as to the order in which those issues were to be addressed. It's understandable why, in the first phase of litigation, HMRC focused on arguments which, if successful, would have made it unnecessary to mount this wider challenge. In the light of those factors, as well as the substantial value of the claims, the importance of the issue to other claimants, both within and outside FII group litigation, and the potential to remedy any prejudice through an order for cost, the Supreme Court allows HMRC to withdraw their concession made below that Section 32(1)(c) applies to mistakes of law, and now to make the contrary case. That case places in question two of the most important decisions on the law of limitation of recent times, the 2006 case of Deutsche Morgan Grenfell and the 1998 case of Kleinwort-Benson. In Deutsche Morgan Grenfell, the House of Lords tied the date of discoverability of the mistake of law to the date when the truth as to whether the claimant has a well-founded cause of action is established by a decision of a court of final jurisdiction. This court considers that Section 32(1)(c) cannot be intended to have that effect, as limitation periods apply regardless of whether the substance of the claim is disputed, and regardless of whether there is in truth a well-founded cause of action. Such an approach also has the illogical consequence that mistakes are not discoverable by a claimant until after he has issued a claim on the basis of the mistake and had that claim decided by a final court of appeal. Given those consequences, it's appropriate for the Supreme Court to depart from the decision in Deutsche Morgan Grenfell in relation to discoverability. The correct approach is that time begins to run under Section 32(1)(c) when the claimant discovers or could with reasonable diligence discover his mistake, in the sense of recognizing that a worthwhile claim arises. That approach brings Section 32(1)(c) into line with Section 32(1)(a), which concerns fraud, and with other analogous provisions of the 1980 Act. The majority of the court accept that Section 32(1)(c) applies to mistakes, as the House of Lords decided in Kleinwort-Benson. Although that decision was not supported by convincing reasoning, and although when Section 32(1)(c) was enacted, it was not contemplated that it might extend to actions for the restitution of money paid under a mistake of law, the ordinary meaning of the words of that provision includes such action. Excluding claims based on a mistake of law would frustrate the purpose of Section 32(1)(c), which is to relieve claimants from the necessity of complying with a time limit at a time when they cannot reasonably be expected to do so. Including such claims does not, in the view of the majority, have unacceptable consequences for legal certainty, particularly now that the approach to discoverability in Deutsche Morgan Grenfell is departed. Since the Court of Appeal applied the approach to discoverability wrongly established in Deutsche Morgan Grenfell, HMRC's appeal must be allowed. But the Supreme Court is not in a position itself to determine, on the basis of evidence, the point in time when the test claimants could, with reasonable diligence, have discovered their mistake. That question is therefore left for the High Court to determine after the parties have had an opportunity to amend their pleading. The Court will now adjourn.